Hi, this is Rahul Reddy from REDDY NEUMANN PC. We are live here every Tuesday at 5 p.m. Central Time. REDDY NEUMANN PC brings immigration news and immigration updates about business immigration. Emily?
Yes, as usual, we'll be answering your questions live. So if you have questions about what we're discussing or other topics you'd like us to answer, feel free to post those in the comments while we're live here, and we'll do our best to answer as many as we can. If we don't get to your question, you can always join one of our daily conference calls. We host those every day. You can find the schedule for that on our website at rnlawgroup.com. Those are free, and you can join into those to ask your questions there, to speak with one of our attorneys. Or if you want more detailed information regarding your specific situation, you can always set up a consultation with us by going to rnlawgroup.com and clicking on consultation. So today we're going to be talking about the latest on the new I-539 application form. We talked about that a little bit last week, and since then we've had a call with USCIS that gave us a little more information. They've been updating a little more on their website in the last few hours, so we'll update you there. We're going to talk about sorry, I'm catching a cold under this wonderful cap season and weather we're having. It's the perfect storm right now. We'll be talking about the lack of premium processing for H-1B cap cases and how that's going to impact specifically for F1 students who are using the cap gap. We'll be talking about all your questions on the lottery.
The expedited removal proceedings that people need to be aware, what kind of rights and what kind of responsibilities that you have when you're trying to enter into the United States. We also are going to look into the visiting visa renewals that we're going to discuss about. Emily, on the I-539 update, that form is used for the H4, L2s, H4 not just for the spouse but also for the kids. Now, they did come up with a new formula. Now, this requires that from March 11th onwards, we have to file a supplement, we have to file the biometric fees, we have to file the new form which does not exist today, and on March 11th they are going live. Any updates on that, Emily?
Yeah, so after kind of some backlash from the public, I would say they modified the rollout of this form. So the form itself, the new version, will be available on Friday, this Friday, March 8th. But you can continue to use the old version of the form up to March 20th. Anything that's filed on or after March 21st, you have to use the new version of the form and pay the biometrics fees. On top of that, because they're kind of having these dual forms being filed at the same time, if you choose to, you can use the new version of the form starting March 11th and pay the biometric fee, but they're going to hold on to your application until March 5th and only, sorry, March 25th. And only starting March 25th will they actually issue receipt notices and start scheduling the biometrics for people that used the new form early. So you don't have to use the new form until March 21st. If you're going to use the new form, expect a delay in getting your receipt notice. And those will be processed.
But you still need to pay the extra $85 fees starting from March 11th.
That's where I'm a little bit confused. I've been talking with the attorneys within our office that also listened into that teleconference call on Friday, as well as we've been reading the updates on the USCIS website. They just put out an email blast just a few minutes ago. I still think it's a little unclear. Other attorneys in our firm say, no, it shouldn't be required until if you're filing on the old form, you use the old instructions, which say no $85. So I think it's a little unclear.
Right now at this point of time, yeah. I would please log into immigrationgirl.com and rnlawgroup.com. The immigration is dilly-dallying on this one because they have not issued the form. They're telling the new form has to be filed on March 11th. Now they are telling we have to file from March 21st onwards. until from March 11th to March 21st, we can use either form. With regards to the filing fees, there is also a lot of confusion about it. Please log on to immigrationgirl.com, subscribe, and also rnlawgroup.com. Emily, with regards to the H-1B cap, you said that you are going to give all the details of the H-1B cap that is going to happen. On April 1st, we have to file application starting from April 1st of 2019. This is for 2020 cap. What should people do right now, Emily?
Yeah, now is the time where the LCA should be in progress or certified or close to being submitted. One important thing to be aware of, if your company has not used the iCert system before, if they're new to H-1B filings, they may not be in the government database for LCAs. That means that you can't submit an LCA until the tax ID number of the company is confirmed. So to do that, we send a document with that tax ID number to the LCA help desk by email, and normally they get back relatively quickly with an email confirming that yes, your tax ID number is verified, you can now submit your LCA. I will tell you the last 4 that I've done took 7 days.
It used to take 5 days before, Emily.
I think even less than that before. So, and that's when we're not super busy yet. I mean, we're not into the super, so you can expect from here it's only going to take longer.
Take longer time.
So if you are in that
are you
situation,
telling that the tax ID number confirmation is taking 7 days? Is that means that the LCA is approved, or is there anything more to that?
No, that's just to be able to initiate the LCA. You can't even submit it until the DOL has verified that number, and the verification is taking 7 days now. So if you haven't started yet and you're submitting it now, it might even be more than a week before you can submit your LCA, and the LCA then takes another week. So that gets you less than 2 weeks away from the filing window opening. So if you have not done that, or if you're not sure whether the tax ID number has been verified by DOL, you need to be doing that immediately.
This week, not next week.
As in tomorrow, not Friday, tomorrow.
Not Friday, tomorrow. That's the best thing that you can do. You should contact the lawyer immediately, get these things detailed. And Emily, is that it? LCA, we filed the LCA, we're done with the H-1B. You need to consider when you're filing a H-1B also whether or not the position requires a specific degree as the minimum requirement. We have noticed that according to the USCIS, they have issued significant number of RFEs last year, and the number one reason why they issued the RFE is that the immigration does not feel that it's a specialty occupation for which the applicants are filing. That's the number one reason for issuing a request for further evidence. So when you're filing an application, it's better to sit down with the HR and your lawyer to see if your position is fitting into the specialty occupation requirement. That means that the position must require a specific degree. Now, there are 2 things here that people need to consider. That it's not just that you have that specific degree, the position must also require the specific degree. The RFEs, the number one reason why the RFE was issued is not because the applicant did not have the specific degree, it's because the position, they feel the position does not require a specific degree. So just because you have a master's in computer science, you're going for a software position, doesn't mean that it's an automatic. The position must require. Now, what happens with these positions is that, there used to be, we were, from the old school, back old days, computer programmers, in 1998, 1999, 21 years ago, we used to get RFEs and denials for computer programmers. Then we evolved from there. We discussed with the HR, and then HR and we all agreed that computer system analyst is probably a better position suitable for the employees and the HR. And we've been using the computer system analyst, and in 2017 they started denying the computer system analyst because the Department of Labor has changed its version with regards to the system analyst, saying that only 45% of the system analyst position requires the bachelor's degree in computer science. And we started getting the denials. So then we sat down and we discussed with the HR, and then probably we came up with different titles which are suitable and which are matching the job description of the individual and the HR, and we agreed upon some of those things. So when you are hiring a lawyer, you better be careful that the lawyer is well versed in the law, because this is an evolving law. Every week there is a changes, every month there is a changes. Your lawyer need to catch up with all those things. I'm not telling that we are the only lawyers. There are a lot of lawyers who are very competent. But make sure that when you are picking a lawyer, you pick a lawyer that is doing H-1Bs as one of their main occupation. It's not they're doing 100 items, H-1B is one of the item, because it's very complex. H-1 has become very complex in the past 2-3 years. Any other suggestions on the H-1B assembly?
Yeah, another thing to start considering right now, if you haven't yet, is whether you're going to request a change of status or consular process your H-1B petition. I think there are 3 main areas where people may want to consider consular processing instead. Number 1 would be a situation where you know for sure that you're going to be traveling sometime between April and October. You may want to consider filing your H-1B in consular processing so that when you exit, you don't accidentally or automatically abandon the change of status request that you've submitted. So that way there won't be extra delays with your H-1B processing because you've already requested consular processing. There's no change of status to abandon or deny in that situation. Another area where you may want to consider consular processing is if you want more control over when your H-1B takes effect. We saw last year that a very small percentage of petitions were actually approved by October 1st, which is the start date everyone was requesting. Once you get past October 1st, if you're in another status in the US, like L1 for example, you usually need to have some kind of advanced warning of when your H-1B change of status is going to take effect. Once you cross October 1st, USCIS is going to make it take effect the day they approve your petition, and you don't know when they're going to approve it, so they could just one day in the middle of November issue the approval of your change of status from L1 to H1, and if your H1 is filed by a different company, you're no longer authorized to keep working for your L1 company. You have to switch to the new employer to avoid unauthorized employment and to prove that you're maintaining your H1 status.
And then we cannot request a date which is further than October 1st because the USCIS requires us to file an H-1B application only 6 months earlier, 180 days earlier. So we can't request December or January or February. We can only request October 1st. That's the only date that we can request.
Yeah, so if you get a consular processing approval, that allows you to continue your current status until you're ready to activate the H-1, and you do that by travel, getting the H-1B visa stamped, and coming back. The third area where you should consider consular processing is those that are in F1 status who have used those day 1 CPT schools.
This is very important, guys, that you need to follow the directions, because we have noticed a significant amount of CPT, day 1 CPTs to H1 conversions getting denied in 2018, and the trend is growing very much on the CPT to H-1B getting denied. And why do you think it's important for them to file consular processing?
Yeah, the most important reason is the unlawful presence memo that took effect on August 9th. That memo says that if USCIS determines you violated your F1 status, you will be considered unlawfully present from the day the violation began, not the day that determination was made. We've seen people who've been on CPT for years. So, if someone has been on CPT since August 9th or even before August 9th, and then USCIS denies the change of status because they found the F1 status was violated due to the CPT, unlawful presence started August 9th, and by the time you're getting that decision, you may have already crossed 180 days of unlawful presence. You may already crossed 365 days of unlawful presence. That means 180 days means you are barred for 3 years from being able to actually get your H-1B visa stamp or any other type of visa. You're inadmissible for 3 years. If you've crossed 1 year of unlawful presence, 365 days, you are barred for 10 years. So that's a huge risk to take in filing your H-1B petition. You can avoid questions into your maintenance of F1 status by requesting consular processing instead for your H-1B petition.
Emily, I'm getting a lot of questions from the YouTube. With regards to the H4 EAD, Emily, and I know a lot of questions are coming on the YouTube, is any updates on it? What is the thing published yet? Of course, last week we were worried that it's going to be published any time. Is it published, H4 regulations?
No, it's still with the OMB for their review process, so nothing published yet, and you can continue to file that. It's going to be an ongoing saga, it appears. So I'm expecting, or my guess, and this is a guess, but just based on the filing deadline that's coming up in the litigation on the H4 EAD, the next round of briefs are due around March 18th, if memory serves me correctly. So I think that is about when we'll see a potential proposed rule coming out so that they can show to the court that they are finally making progress on that.
Mahesh has a good rumor. I won't present it as a rumor, but he has a rumor. I have some rumors flying around that for the fiscal year 2020, starting, that means that filing of the H-1B applications in this one, that they require a biometrics.
Oh, that is a good rumor, but it's not true. The biometrics are only required for I-539 applicants. H-1Bs are filed on the I-129 form, so there is no biometric requirement for H-1B holders. The I-539 is used for F1, B1, B2, H4, L2, TD, E3D, O3, P something or other. I'm trying to go down the alphabet. Yeah. It's generally for dependents of the main applicant. Those are the people that use the I-539 application. So no, it would not be required for the H-1B applicant to get the biometrics.
Mahesh, that's at least as of today.
Right. This could be coming in the future. We don't have any official word saying that's what's happening. There's no, we do get advanced warning of these things. It's called an information collection review. That's part of the regulatory process. And they actually have to submit that proposed information collection. The form is actually referred to as an information collection. So we would find out if that's what their plan is, but I don't think there's anything in process for H-1B holders at this time.
Somil has this question from YouTube, Emily. The position title has changed. Does it require an amendment? Well, it depends on Somil whether or not title change by itself is going to change the SOC code, the underlying the position for which you have been hired for. Sometimes the titles are just what we call as a functional titles. You know, people come and tell to us that I'm an architect. What do you mean architect? We dig into that guy has no architectural degree. He's a software guy. So architect is technically for us is the one who builds the building. So when you're saying that you are an architect, you're actually a software person. So we look into not the architect title, because architect title goes to the people who design buildings. That's not what people do. Some of the software architects, they don't do that. So we don't look into the title alone itself. It's a job description that will tell us whether the person belongs to a certain position or not. So if the title, mere title has changed, by that itself may or may not require the amendment. But I would have the HR check with the lawyer to see if it requires an amendment.
All right, I have a couple of questions on H-1B transfer, so I'll try to go through those quickly. One question, how long is it taking to get the receipt notice? Not anything out of the ordinary, probably 7 to 10 days these days to get the I-797 receipt notice in the mail for a receipt. Next question is, can transfers be filed in premium processing? No. Only those that were filed before December 21st can currently be upgraded to premium. If you're filing a transfer now, there's no premium processing for that. And then the next question is, can we start working on the H-1B transfer receipt? Technically, yes. If it is a timely filed transfer, meaning while you're still maintaining your status with your prior employer or within the 60-day grace period, yes, you are authorized to start work for the new employer as soon as the transfer is filed. There are some risks involved in that. If it's not a strong case, that may not be a good idea because there's a high chance of denial. And once you join the new company, if a denial happens at that point, that denial puts you immediately out of status. Especially if your I-94 has expired while your transfer is pending, then it's even riskier because not only are you out of status when the transfer gets denied, you also start accruing unlawful presence the day after the denial is issued. So yes, you can join the new company based on the receipt notice for a transfer, but you better be really careful to make sure you are comfortable knowing that your transfer has a good chance of success. If there's any risk of denial, if you're not sure, it may be best to wait and not join based on the receipt.
Kalyan has this question with regards from YouTube that he has a pharmacy degree and he is not eligible for the STEM extension. Can he file H-1B as a pharmacist intern, or can he file as a future pharmacist? One thing is for sure, you cannot file as a future pharmacist. The position must exist on the day of filing. You must be eligible for the position on the day you file the application. So on April 1st, when you file the application, you don't have a license for pharmacist. No, you cannot file a future pharmacist position at all. You must have the license for the pharmacy when filing an application. When it comes to the pharmacist intern though, it's a big debate whether or not the position requires a specific degree or not. Yes, you should make an attempt to file a H-1B if I were you, but a clear documentation need to be there that the pharmacist intern requires a specific degree, which is a pharmacy degree. What do you think of that, Emily?
Well, I know there is some guidance about licensing issues. If you are in the process of getting your license, but for some reason the state won't issue you your license because you don't have a social security number or because you don't have work authorization because your H-1B is not approved yet, USCIS can actually approve a 1-year H-1B based on a pending license, and then to file your extension, you have to prove that you've received the license. That is a memo, a guidance memo that was put into the regulations. So definitely discuss that with your attorney to understand whether you meet all of the requirements that are set out in that memo, or whether the intern option is going to be better for you.
The key thing for that, what Emily said is, as what she pointed out, was that did you meet all the requirements for the licensing? If the only thing that is waiting is either your social security number or your H-1B, that's when you can file for the H-1B as a pharmacist. What about with intern, Emily?
Yeah, I think it really, I would expect a request for evidence on that about whether that job is a specialty occupation. It might be tough to get that approved. Question coming from Facebook. I'm on my OPT extension that's valid through 2020, and I'm filing an H-1B this April. Can I travel while it's in process? That goes back to what we talked about earlier. That may be a good situation where the H-1B should be filed in consular processing, since you know you're going to be traveling while it's pending. That way you avoid abandoning the change of status and causing some issues for your SEVIS record.
L1 is expiring in October of 2019. If the person files an H-1B and selected in the lottery, is not approved in the country after October 4th of 2019. Yes, you can stay in this country. Absolutely no problem with that. The key point here is that your L1 is actually expiring after October 1st. If it would have been expiring before October 1st, it would have been a different story. Since your L1 is expiring after October 1st, yes, you can stay in this country, but you cannot work on a H-1B because it's not approved yet.
All right, if there's any options to expedite an H-4 EAD, it was just receive the receipts. The options for expediting anything with USCIS are quite limited. They have specific expedite criteria to extreme humanitarian issues, life or death kind of to be of emergency situation, extreme financial hardship, or USCIS error. Those are the reasons that come to the top of my head. You have to call customer service and request the expedite. I will tell you, I did this just last week. I sat on hold for over 45 minutes. Those of you that follow me on Twitter probably saw that. And listened to the wonderful music that USCIS plays while you're on hold. Put in my expedite request that was due to USCIS error, and within 10 minutes I got an email denying my expedite request because the application was already with an officer and I should hear something in 30 days. So
do you normally hear them in 130 days?
No. And this had been pending already for 90 days, which is beyond the normal time. So I have very little faith in USCIS's ability to expedite anything. I don't see it happening very often.
It's not just this H4 expedited, Emily. We don't have a premium processing. People are willing to pay. The 485s, they're delaying it. H4s, in general, they're delaying these things. So delaying has become a habit of torturing the immigrants. Delaying is the way the Trump administration has put a wall on legal immigrants. However, we have found a new way. I mean, we are forced to find a new way of going to the courts. We used to be very hesitant in going to the courts. And recently we started doing it. We're getting good results in it. Typically, we get a good results in approximately 80 to 90% of the cases, but then it still takes anywhere between 3 days to 3 days to 57 days. That's a timing, because when we file a federal court case we're not even asking to expedite, because the immigration is supposed to adjudicate these petitions within 30 days, most of these things, H1, H4 EADs. That is according to the Congress. Most of these applications supposed to be adjudicated in 30 days. Come on, they don't do that in 30 days anywhere. Not even the dreams they do it. Only in premium processing they do it. So if you go to the court, and there is a good chance that you will get your case adjudicated very early. But of course, it's going to be a little bit expensive, and it still is going to take it might take between 30 days to 60 days by the time you get a result.
Jitendra has a question about, can we convert an EB2 I-140 to the EB1 category? And if we do, what happens if the EB1 is denied? Can we still rely on the EB2 I-140 for further H-1B extensions? So you don't really convert an EB2 into EB1. It's a separate filing under separate criteria. What you do with the EB2 is port the priority date. So you file an EB1, and if it's approved, you can retain the EB2 priority date. The EB2 approval is still there. So if the EB1 gets denied, it has no impact on the EB2 approval as long as the employer didn't withdraw it.
Is EB2, Jairo has this question, is the EB2 approval possible if the application is out of status? That's not a consideration whether the person is in legal status or not. The USCIS will still adjudicate the EB2 independent of your status, though.
Yeah, so the EB2 is determined with the I-140 petition. An I-140 petition, you don't even have to be in the U.S. at all for. It's later when you're filing your adjustment of status, the 485, that's when you have to document your status. One of the topics that I mentioned at the beginning that we wanted to discuss today was B2 extensions. I get a lot of questions from H-1B holders or L-1 holders who are here, and they want to have their parents visit them on a B2, and they come in on their B2, they have a 10-year visa. How long can they stay? Can they stay for 10 years? The visa's valid for 10 years.
It's the I-94 that will determine how long they can stay. Typically, they are allowed to stay between, typically, 6 months is 95% of the time. The question that pops up is that when they come into the country, people would like to extend their visiting visa beyond 6 months. The first doubt that comes is that, I understand the culture where some of the immigrants are. The parents come and stay with the children for a long period of time. But you need to understand the culture here is quite different. The parents are just visiting here. So when they're visiting here, it raises a lot of doubts in the minds of the USCIS officials when the parents want to visit the children for more than 6 months. There are ways to do it, but it creates a doubts, and we see a lot of denials. And before you even take that option, I would recommend that you contact a lawyer, because there are some minus points to it. I mean, what are the things that you come across when you file the B2 extensions?
Yeah, one of the major issues is the processing time. So when you're filing the B2 extension, it's the I-539 application, which means starting March 21st, you'll have to pay the biometric fee and go for fingerprinting. So processing times are probably going to be even longer. But the maximum request you can make is 6 months, but the processing of the application might be 15 months. It's very likely that you won't ever get a result on the B2 application by the time the stay you're requesting has ended. Now, normally we tell people if you have a pending application, you are in a period of authorized stay and you can continue to stay the entire time it's pending. That's not the case for a B2 where you've only requested 6 months. If your application is still pending at the 6-month mark, you can't keep staying in the country. That kind of goes against what you requested. You're saying you only wanted to stay for 6 months, yet you're staying longer. And once you do stay longer, or say you do stay and that application ultimately gets denied, this is huge. You need to understand that when your B2, your I-94 is expired and your I-539 is pending and then it gets denied, you're immediately unlawfully present, you're obviously out of status, and that unlawful presence voids your 10-year visa. So you no longer have that 10-year visa. It's immediately void, no longer valid. You have to go for a new B2 visa stamp, which you may or may not get because now you've overstayed. So those are some of the things that I think are important to be aware of.
In general, I would recommend that please avoid filing the B2 extensions, because about 80% of the time we see them getting into more trouble than their benefit that it is derived from. Emily, I want attention of you in this case. Tej from YouTube has this question. He has a notice of intent to revoke issued on an internal project H1B that was approved in 2015. He now moved on to a different company. He's even got his I-140 approval. That notice of, practically, it was approved in 2015, Tej, I'm assuming that the validity period is already over for that one. This has become a very serious matter and this is not the first time, Tej, that I'm receiving this. In the past 1 month, I've received about 7-8 requests. And surprisingly, they are starting going back to 2015, the H1Bs that were been approved for the internal projects. Now, we know what Tej means by internal project. Come on, we're not ignorant about those things. What do you say about this? What is the trend about this?
Even though the petition may have already expired, where you have to be really careful is if this was your first H-1B approval notice. Yes,
that's the first H-1B cap.
If it gets revoked, they may now say you never were counted in the cap, and so everything you filed after that is going to be revoked.
Should not have been approved.
So this is a very serious matter. You definitely need to speak with an immigration attorney to understand what the possible outcomes could be.
It's not just a serious matter for Tej, it's also a very serious matter for those people who are contemplating on filing a H-1Bs, where we have a lot of doubts whether the job exists there or not, particularly those internal projects that people are telling about. If you are contemplating and filing, Tej has his H-1B approved in 2015. Now it's 2019. 4 years down the line, you see the problem. We have also noticed some problems before, but in the past 2 months, we have noticed that these kind of notice of intent to revoke has been a lot more in the past 2 months. So and another lesson for the people who are contemplating and filing a H-1B, duplicate H-1B. They are working with company A, with an end client, they are filing the H-1B, that looks to be good to us. They are going to another company to file another H-1B application with an internal project, and we know that internal project, okay? I don't want to explain very detail on this video. So when you're filing the H-1B, you may get this H-1B approved, and we are noticing that the immigration approves these H-1Bs more frequently and more not even questioning easily these internal projects because they want to revoke your H-1B at a later date so that they want to put you in trouble. So please don't file the H-1Bs with these so-called internal projects. Don't file those things. You will get into trouble. Maybe today you'll get into trouble later on. So don't try to do that. This has been a very, but Tej, in your case, we advise you to contact the lawyer immediately because there is a good chance this H-1 will be revoked and your subsequent H-1B will not be valid also.
Speaking of getting into trouble, one of the topics we mentioned that we wanted to talk about today is something called expedited removal. Expedited sounds good, but in this case, it's not. This is basically a very fast deportation process that happens at the airport when you are arriving into the U.S. So normally when you're coming into the U.S. on whatever type of visa you are
Emily,
here
is it
for.
only the people who don't have the visas that will be expedited removal, or is this expedited removal is applicable for the people who have a valid visas?
Yes, this can also be for people who have a valid visa. So yes, someone who's coming in without documentation, someone who's trying to cross illegally, typically that's where you hear about expedited removal. But even if you have a valid visa and you're coming for the proper purpose, it is going to be up to the officer at the port of entry if they are making a determination that there's some sort of fraud or misrepresentation going on in how you got that visa stamp or what you're saying now to the officer compared to what you said before, they can put you into expedited removal right then and there. There's no judge, there's no opportunity for a hearing, there's no appeal, there's no access to a lawyer. And if they decide that you were trying to enter based on, received your visa due to a misrepresentation or fraud, or what you're saying now is misrepresented compared to what you said earlier when you applied for the visa, they can deport you right then and there back to your home country. And when that happens, they're going to subject to a 5-year bar. So it's not just that you're going to be forced to go back to your home country.
The visa is canceled and you have a 5-year bar.
Right. Now, I bring this up because we've most recently started seeing this in situations involving
Day 1 CPT.
Day 1 CPT and people coming in on F1 for these universities where you attend class once a semester, 3 times a semester, once a month, and everything is done online.
No, it's not. It's like 6 days a year, 2 semesters, 3 days a year. We have noticed a significant amount of people getting expeditedly removed when they are trying to enter from the F1 visa into the country. The CBP, the Customs and Border Protection Officer, asked questions to the students. Have you attended the classes? Do you physically attend the classes? And when they knew that these people did not physically attend the classes, they were attending the classes online, they were being expeditedly removed. So this is the #1 reason that we are noticing at this period of time. And we have also noticed that some of the students who are coming into United States who have had some jobs in restaurants which they are not allowed to work in. And when they are working in those restaurants, we have seen those people also being expeditedly removed. We have also noticed that some of the H-1B visa people, they are not working at the same location which they are supposed to work at on their H-1B petition. They were also expeditedly removed. Emily, you said that there is no lawyer, they are expediently removed from the airport by the CBP. And now, what about their rights, the constitutional rights that they have? I want to address some of those issues that these people have WhatsApp, emails. What happens there to the CBP? What is your experience when you have spoken, or when we have seen the sheets that they have given by the CBP?
Yeah, I think your rights are very limited at that point. Yes, you've touched ground on U.S. soil, but you're still in the airport. You're not yet admitted into the U.S., so you aren't really given the same due process rights or constitutional rights that someone on the other side of the CBP checkpoint would get. So we do know that many times they will take your electronic devices and ask for passwords and open those and read emails, read text messages, and use that information to ask further questions, and then find those inconsistencies and use that as a reason to deny entry and further say that your visa is no longer valid, and expedited removal, 5-year bar, all of that can be done.
At this point of time, based on the court's interpretation, practically they can get your passport. They will force you to give you the passports. If not, they'll put you in the detention until you give you the passports. That's how they are interpreting at this point of time. With regards to whether or not they can scan your computer, they can scan your deleted emails and all those things, definitely it looks like, according to the Ninth Circuit, they require a judge order though. But to get the password and see your emails and WhatsApp, Facebook and other things, most probably doesn't look like you have much rights when you're entering into the United States. So when you're communicating, if there is any communication, that probably a resume that you might have sent, which might have inaccurate information, is one of the big reasons for expedited removal too. So if you're traveling, you have those things, definitely that's going to put you in trouble.
Priya from Facebook asks, we talked about choosing consular processing instead of a change of status and what circumstances you would do that. So she asked, well, what are the risks of consular processing? Is there any risk to doing this consular processing? And of course the answer is yes, there's always a risk to anything you're doing in immigration. But the risk is you go to the consulate, you apply for your visa stamp, you could be denied the visa. You could be subject to 221G or administrative processing that causes extreme delay in getting that visa issued. So certainly there are no guarantees that just because you've selected consular processing and you go and get that visa stamp that you will get it and can return. But by selecting consular processing, it allows you to avoid maybe some more grave or serious issues that could come up.
Chitty has this question: can I file my husband's H4 and EAD extension along with the H1B? Yes, you can. We strongly recommend that you file H1, H4 and EAD. They will be adjudicated together. Having said that though, at this point of time, you might want to strategize because of the fingerprinting requirements for the H4 on the premium processing. You may want to delay your premium processing until the H4 person got the fingerprints done, and once the biometrics has been done, you may want to expedite, because if you just expedite, your H1B might be approved and H4 EAD might be delayed. That's the reason. But in general, please file H1 and H4 EAD together. That would be in your best interest.
Speaking on the H4 question, is the biometric mandatory for all I-539 applications or just certain types? And it is for all of them unless you are a diplomat, A, G, or N type of visa. Everyone else, it is mandatory regardless of whether you've been fingerprinted before, whether you filed an extension and been fingerprinted before. The fingerprints that you did submit when you were getting your H4 visa stamp at the consulate, the State Department has those. This is Homeland Security. They do not share those fingerprints, so that's why now Homeland Security is wanting you to be fingerprinted while you're here, and they'll keep doing it every time you file a renewal.
Every time?
Yep.
Does I-539 is required for a first-time B2? I didn't get the question, Mr. Siddhi. When you're saying first time, do you mean when you're applying for the visa in your home country? No, I-539 is not required. The biometrics are taken there anyway by the Department of State. It's not required to file it. But once you are in USA, if you're filing for the extension, you need the I-539.
Srikanth has a question. He joined a new company after his H-1B transfer is approved, but now wants to go back to the previous company and wants to know if he can do that and if there'll be any issues with getting the extension with that company. So once you have your transfer approved, the previous company's approval is still valid unless they've withdrawn it or it expires. It's called a dormant H-1B at that point. You can go back to that company and that H-1B at any time while it's still valid and then continue your status on that H-1B, file extensions of that. Should not be an issue at all.
Johanna has this question from YouTube. How long it's taking for the H1 transfer? It's taking anywhere between 4 to 8 months for the H1B transfer, and if there is an RFE, you can add 4 to 5 months on top of that after you respond to the RFE. However, as you know that if the transfer, they have activated that if you file the H1B transfer before December 21st, that means approximately around 3 months or so, you can file the premium processing. Hopefully, we're expecting premium processing might be fully available, but at this point of time, it's not there. It's 4 to 8 months, 6 to 8 months for the H1B, and if there's an RFE, add 4 to 5 months.
Kieran has a question on Facebook. If someone overstays their I-94, maybe just for 7 days, and then they go back to their home country, when you're applying in the future, is it necessary to say you've overstayed when you're submitting that DS-160 application? Absolutely. Even if it's 7 days, even if it's only 1 day, if you overstay by 1 day, if any application that you submit in the future asks, have you ever overstayed, you must say yes. You cannot misrepresent that. It's not that you're going to be denied for the overstay for 1 day or 7 days. If you misrepresent it, you're going to be denied for the misrepresentation.
That's a bigger problem.
Yes. So absolutely, you must answer those questions truthfully.
Sheba has this good question. I received an RFE, an amendment. Can I apply for a transfer to the end client without responding to the RFE? If your I-94 for the underlying, not the amendment, the underlying H-1B has not expired, I do not see any problem whatsoever at all for you to transfer to the end client. Though your RFE is pending, it does not require to be approved. While the RFE is pending for the amendment, you can file the transfer. You will not have any problem just because you have an RFE.
Somyadeep has a question about applying for an H-1B in the CAP when the master's degree is not yet complete. Can you file in the master's quota? Possibly. It depends on the situation. If all of the degree requirements have been met, just the degree certificate hasn't been issued yet because their graduation date is actually sometime in May after the CAP filing window closes. If you can get a letter from the registrar confirming that the degree requirements have been met, you can still file in the master's CAP. If your degree requirements have not yet been met, you have to file in the bachelor's CAP.
Can an Indian-born Canadian citizen apply for the GC if they're already on TN visa in US? This is a question from Ram from YouTube. The answer is yes, you can file for the green card, but you're not coming under the quota of the Canada. You'll be coming under the Indian quota, which requires God knows how many years for you to get the green card. So it's not, you won't come under the Canadian quota. So yes, you will have to wait for a long period of time. Nice thing. One question.
Yes.
Sahil has this question. Can one file a O1 visa while waiting for the EB1485 approval? We don't see any problem in filing the O1 visa when they're waiting for the EB1 approval. You can file for O1 visa, not a problem. The qualifications are for O1 visas almost similar to EB1. So you might, if you want, you may want to file the O1 visa.
Yeah, the O1 isn't exactly a dual intent visa. It's called quasi dual intent. But having an approved or filed I-140 petition by itself is not a reason to deny the O1. Smita asked if you can work based on an H4 EAD renewal receipt notice.
No.
No, if your EAD has expired, this is specifically H4 or even L2 EAD, if it's expired and you don't have the new card in your hand, you have to stop working until the new card comes in. You're not authorized to work. That's a different story if this is a STEM extension for OPT or a EAD based on a pending I-485. In those two situations, you can work for up to 180 days based on a pending receipt notice.
Anand has a very good question. His brother worked on H-1B for 3 years. He left to India 5 years ago. He has his I-140 approval. Hopefully the I-140 was not withdrawn for 180 days. Even if the I-140 is withdrawn or not withdrawn, you can still come back on H-1B, absolutely no problem. You can only use the rest of the 3 years unless the I-140 validity is there. You can use it, but yeah, you can file the H-1B. Your brother is not subject to cap.
Question, can H4 dependents study in school? I'm assuming yes. So if you are talking about studying in college, if you're on H4 as a minor, maybe you graduated from high school and now want to attend college, yes, you can do that while you're on the H4 until you turn 21, or an H4 spouse can also attend school. No issues with that at all. City has a question on the, I think you already answered that, on the I-539 for the visa, the B2 visa. So just to make it clear for everyone, if you are applying for your B2 visa outside the U.S. at the consulate, there is no I-539. It's a very similar situation to someone who's applying for an H4 for the first time. There's no I-539, you just apply at the consulate. Once you're here in the U.S. and need to extend your stay on an H4, a B2, an F1, any of those, that's when the I-539 is necessary.
Harun has this question. My employer said that I-140 has been filed. He doesn't give me the information or the receipt notice. For those people, a lot of people whose employer is hiding the I-140 information, you can go to USCIS site. It's called FOIA, Freedom of Information Act. And believe me guys, this is one of the best thing I've noticed in the Trump administration. That works so good. No filing fees is required. And the processing time has come down. This is the only thing that I can remember in this administration, the processing time of FO, Freedom of Information Act, has come down. So if you file that information, you will get a copy of the I-140 application file that has most of the information required, especially the file number that you need it.
Prabhu has a question. He's got an H1 currently with a U.S. company, and the company is not doing well, looking at filing bankruptcy. If they do a layoff, what will happen to him? Unfortunately, I'm sorry to hear that you're facing that situation. You do have the 60-day grace period because you've mentioned your I-94 is valid till 2020. So if the layoff occurs and you can find a new job with a different company within 60 days, you can file an H1 transfer to the new company to continue your status. If you are married and your spouse is on H1, you could use that 60 days to file a change of status to H4. Though that would also be a good option during that time.
Navin has this question from the YouTube. How long it's taking for a PERM application to be adjudicated? It's taking approximately 3 months for the adjudication of the PERM application. That has been a very, unless there is an audit, 95% of the cases do get adjudicated approximately 3 months. Another question that came from Anam, she filed a adjustment of status application under EB3. How long does it take for it to get the interview? As probably our audience already know, if you file an adjustment of status on or after March of 2017, you will get an interview process. It's taking approximately 18 months to get the interview. This is just an approximate time that I'm giving it to you. A lot of questions, Emily. It's time.
Yeah, sorry we're not able to get to everybody.
Please don't forget to subscribe to the news we have at rnlawgroup.com. There's a news section that we do. We do give update. And Emily has her own blog. It's immigrationgirl.com. And she keeps everything, any news that comes in, she publishes it immediately. And if there is any hot news that pops up, H4EAD or anything that pops up, we will do the Facebook and YouTube Live immediately. For those people who wants to make an appointment with me, Emily, or any of our colleagues, please go to rnlawgroup.com and then you can make an appointment. Our schedules for appointments are online. Emily? Anything?
All right, thank you for joining us. We'll be back next Tuesday.